here real quick before I say too much. But we are on our way back from court in San Antonio. For those of you that like to look at my ties, today is a sort of a cutout Rudolph type. Actually, it's just a reindeer because it doesn't have a red nose. So, a little reindeer tie and another Christmas jacket that I'm wearing today down in San Antonio court. And we are on our way home. Anyway, I'll go ahead and get started. So, I had a client hired me because he had an LTC. He's an LTC instructor. And he got a letter from DPS saying that, hey, we're suspending your license or revoking your license because you've got a protective order filed on you. And so the story is that this protective order was filed back in 2001, 24 years ago, almost 25 years ago. Him and his ex-wife were going through a divorce, and she had made some bogus accusations, and they weren't even violent accusations, but you know how people get when they're going through a divorce. So she had applied for a temporary restraining order. The judge granted a temporary restraining order pending a hearing on the matter. And hang on, I'm gonna turn this off real quick. Come on. And then after a hearing, what the judge ended up doing, because none of the allegations were substantiated, but the judge issued a protective order that they were to both leave each other alone, right? It wasn't because he had committed violence or she had committed violence. Well, although she did commit violence against him. So there was no finding of violence, and that is required under 922G. G8. So under 922G8, under the federal code, 18 USC, there has to be a finding that there was violence, right, in order for a person on a protective order to be essentially a prohibited person. And so we, and this is, again, 24 years ago, right? He's been married now for 22 years to another woman. Everything's great. And he had an LTC for the longest time. Again, he's an LTC instructor. He's bought guns through FFLs and was never denied. And of course, the reason he was never denied, and this is what the DPS argued, the reason he was never denied was because he didn't tell the truth about being under a protective order. But 922G C1 and 2 are very specific that you have to have that protective order, and there has to be a finding of violence. So since there was no finding of violence, he's not required to report on the 4473 when he buys a gun. So we had, once he got that letter, he hired me. I filed an administrative appeal, asked for a hearing on the matter. We went to a hearing on the matter before a magistrate judge at a justice of the peace. The magistrate ruled in our favor. It was great. We won. Woohoo! And the judge ordered that they reverse their decision to revoke his license. Well, they appealed. DPS appealed, and which is kind of good because now we're in a court of record. And so today was the court date in county court in a court of record. And we made the same argument that not only does he not meet the elements under 411.172, which is the LTC code, because 411.172 requires that there be a spousal relationship. Well, there is no spousal relationship. They've been divorced for 24 years now. And so that 411.172 does not apply in this case, so they can't revoke his license based on that. And then, of course, they went off of 18 USC 922G, and then specifically they were claiming C2 as their basis under the federal guidelines to be able to deny him an LTC. But if he fell under 922G, then he would also be a prohibited person under federal law from being able to carry a firearm or buy a firearm or anything like that. And so we made that argument. The state made the argument that, look, he's got a protective order, so we've got to suspend it. The judge disagreed, said they don't meet the elements. We successfully argued that DPS has not sustained itself, or not sustained its argument that he's a prohibited person under either state law or federal law. And now my client's about to get his license back. So 2 in a row. But my Second Amendment defense record remains at a whopping 100% success rate. So if you've got a Second Amendment case, whether it's self-defense, whether it's your rights being violated, whatever it is, wrongfully denied a license to carry, I'm your guy. I'm the one. Texas 2A attorney, and pretty soon gonna have Ryan over here. I can't really move my camera over there. So we'll have another attorney fighting you guys. Sorry, it's all shaky. All right, that's it. That's all I wanted to tell you. You guys take care. Be safe. Be free. Keep winning.
Like and subscribe.
There you go. Like and subscribe.